Everyone, the dispute between Benue State Governor Heinz Italia and the state's embattled Chief Judge Justice Morris Ekwambeze has intensified, with both sides exchanging accusations following the latter's controversial removal. Last week, the Benue State House of Assembly, acting on a letter from Governor Alia alleging corruption, approved Ekwambeze's removal. The decision has drawn criticism from the Nigerian Bar Association and the National Assembly, but demanding a reversal. Breaking his silence in a viral video on Sunday, the CJ, who also alleged that an assassination attempt was made on his life, also linked his alleged removal from office to his refusal to assign certain judges to sit on the Election Petitions Tribunal for the local government election. Ekwambeze claimed he was removed from refusing to appoint the governor's preferred justices to the local government election petition tribunal. He insisted he remains the legitimate chief judge. The Senate has urged the National Judicial Council to resolve the purported removal of Benue Chief Judge Justice Morris Ekwambeze in line with constitutional provisions. It also urged the Committee on Judiciary and Human Rights to investigate the matter and report back in 2 weeks. Tonight, joining me on the program for another legal perspective to this matter is Madaki Gwaza Michael, a lawyer and public affairs analyst. Good evening to you, Mr. Michael. Thank you very much for joining us on Politics Tonight. Thank you.
Thank you, Olajimoke. Thank you for having me.
Right. So interestingly, the Senate has shown interest in this matter. There are some senators who have said the Speaker of the Benue State House of Assembly was acting as script, and the agency has now given a verdict on it, which says that Honorable Justice Ekwambeze remains the Chief Judge. What's your perspective about what has been called a looming constitutional crisis in Benue State? What do you think is happening?
Okay, thank you once again. I think the matter is straightforward. You have a situation where, in the full practice of democracy, you have the executive, the legislature, and the judiciary acting together, all to give Nigerians the best of governance. And in doing that, all these various arms of government have to exercise their powers in a way to bring progress and also check each other. So the judiciary has the responsibility of answering to the executive and the legislature, and the highest check that gets to be provided, is provided for under the Constitution, relates to the power to remove the chief judge of a state. And that is provided for succinctly under section 292 sub 1A sub 2 of the Constitution, where it lists clearly that it is the governor and the House of Assembly that have the powers to remove the chief judge. A few lines down on that, in that very section 292 sub B, it makes provision for the removal of a judicial officer. Now, the Constitution goes ahead to provide that to remove a judicial officer, it has to be with input from the NJC and the governor and the House of Assembly. So, in my view, and as going by the clear wordings of the Constitution, what happened in Benue State was proper. It was according to law. Oh, Nigerians have struck again. It was proper according to law, and the legislature was simply exercising its powers in that regard. Now, please pardon the interruption. Power will kick in a few moments. But I need to point out that that section makes provision that the legislature will send a resolution to the governor. It is the governor that will properly act on the removal. You know, it comes from even the process of appointment. When a judicial officer is recommended to be appointed as a judge or the chief judge of a state, it remains a recommendation until the governor acts on it. So for now, that recommendation has been sent by the Benue State House of Assembly by law, by going through and obeying the letter of the provisions of the Constitution. It is for the governor now to act on it, and that is what we are waiting for. Remember that aside from recommending that the governor should remove the chief judge from his position, they also made a recommendation to the NJC that the chief judge should remove the judicial officer. Now, to remove as a judicial, he should be removed as a judge entirely.
So that was the
That is the
day
provision
after, Mr. Michael, let me comment, that was the day after the removal of the chief judge. But if I'm clear enough, what you've said tonight is that the NJC is not saddled with the responsibility of appointing and firing any judicial officer. Is that what you just said?
I am saying it does not have a hand by the letter of the Constitution in removing the chief judge. It is under Section 292, succinctly provided for.
So because
you've
mentioned Section 292, let's be clear about this Section 290 of the 1999 Constitution, 1A, which states that a judicial officer shall not be removed from his office or appointment before his age of retirement, except in the following circumstances: Chief Judge of a State, of Grand Cadi of a Sharia Court of Appeal, or President of a customary Court of Appeal of a state, by the governor acting on an address supported by 2/3 majority of the House of Assembly of the state, praying that he be so removed for his inability to discharge the functions of his office or appointments, whether arising from infirmity of mind or of body, or for misconduct of or contravention of the Code of Conduct. So this part of the Constitution is what the State Assembly says stamps its rightful place to remove the state chief judge. And that's what you're saying is valid tonight, isn't it?
Yes, that's what I'm saying. As you have read from your own wordings, the NJC is not mentioned. But if you go down, just the very next subsection, it speaks about the removal of a judicial officer. That means a judge. So it is in the process of removing a judicial officer, that is somebody from totally serving as a judge, that the NJC is involved. If you just look the following next section down. So clearly, it couldn't have been a mistake by the framers of the Constitution to, in one breath, make provision for the removal of the head of court, chief judge, the Grand Cadi, or the president of a court of appeal without recourse to the NJC, and then in the next breath, make recommendation for the removal of that person as a judge entirely with the inclusion of the NJC in its functions. Now, I've also stated that the House, in the first prayer, was to remove Milord Justice Piambese as the chief judge, and then the second prayer was to recommend him to the NJC for investigation. In that prayer, he is now going to be removed as a judicial officer if the NJC concludes its workings and finds that the allegations are proper. So there are two distinct issues here. The first issue does not require the NJC. The second issue requires the NJC.
All right. I mean, if you're here tonight to say the NJC does not have a hand in the removal of a judicial officer, I wonder why the NJC has now called what the State House of Assembly in Benue State has done as illegal and invalid. Now, NJC has urged the state government to adhere to the provisions of the 1999 Constitution regarding the appointments, discipline, and removal of judicial officers. The Constitution is supposed to be clear and unambiguous, and I wonder what this means for us as a country, especially when lawyers on one hand say our laws, our Constitution, which is the supreme law of the land, is not ambiguous. On the other hand, you can test the law. Section 290, just like I read out, there is a part B of that section which states that before you can remove a judge, a petition must be written against the judge to the National Judicial Council, NJC, and they will determine to hear it. It is after they've heard it, they can decide to clear him or suspend him and recommend him to the governor to remove him. Unless NJC recommends to the governor to remove the chief judge, the governor cannot act. So who takes the day in court?
Okay, so from what you just read now, there are two provisions: to remove the head of the court, who is the chief judge, and to remove him entirely from acting as a judge. You need to get that. The issue is a bit close, but it is different. You must first be a judge before you are appointed a chief judge. So to remove you as a judge, we do not need the NJC to come in. It's from the very words of the Constitution that you read. It is to remove him as a judicial officer that requires the NJC to come in. But again, let me just even say, and then before I go on, with the utmost respect to the institution of the NJC is not an arm of government. The NJC is just a creation of the Constitution to function under the judiciary. The arms of government are the executive, the legislature, and the judiciary. So let us not presume to allocate so much powers to the NJC beyond what it is constitutionally provided for. But again, let's assume that everything that happened here was wrong. Let's say the House was wrong and it read the Constitution upside down. Let's say by dint of whatever extraordinary circumstances, the governor was wrong in taking the steps to write a petition to the House of Assembly. Under this very democracy that we practice, what is the way forward? If a step has been taken purportedly to be based on the Constitution and you feel that it is wrong, what step are you supposed to take in a democracy? Section 6 of the Constitution provides that. It provides for powers of the judiciary. You can simply go to court and ventilate your grievance.
Mr. Michael, are you there? Can you hear me? So if you can hear me, you know, your colleagues have described this as a slap on the face of the judiciary, especially when the Supreme Court had settled. Mr. Michael, are you there? Mr. Michael, can you hear me?
And state this position, plus rancor into the system.
All right. Please go ahead with your thoughts. Mr. Michael, if you can hear me, you know, your colleagues have described this as a slap on the face of the judiciary, especially when the Supreme Court had settled this debate in May 2009, when it ruled against former Governor Bukola Saraki for unlawfully removing the Chief Judge at that time, Raliat Elilu Habib. The Supreme Court is the highest court in the land, and its judgments are final. So even 2023, we're still having this kinds of issue. What does it say about the kinds of democracy we practice here in Nigeria?
Hello, Jumeke. I don't know. I just got in. I didn't hear your last part of the question, please. Can you just refresh that a little bit?
All right. I said your colleagues, I mean, you're a legal practitioner, so I can say your colleagues have described this as a slap on the face of the judiciary, especially when the Supreme Court had settled this debate in May 2009, when it ruled against former Governor Bukola Saraki for unlawfully removing Chief Judge Raliat Habib. The Supreme Court is the highest court in the land here in Nigeria, and its judgments are final. In 2023, it reoccurred in Osun State, where Governor Adeleke sacked Justice Oyebola. This is happening again in 2025, which you would agree with me would definitely create disillusionment in the minds of ordinary Nigerians, wouldn't it?
Okay, so the Supreme Court case in Kwara State, Abia State, and all of that, you know, all matters came to a head in the case of Justice Onogen, when President Buhari removed him as the CJN, Chief Justice of Nigeria. The agency was not involved. Now, a couple of senior advocates of Nigeria, eminently qualified advocates, they decided on themselves that, look, the Kwara State case that the Supreme Court had decided on in 2000.
All right, we seem to be having issues with
the Supreme Court to have an opportunity.
All right, Mr. Michael, we need to go on a break, and when we come back, we'll continue this conversation. Please stay with us, everyone.
Doubt and fear doesn't occur at the canvas, it shows in the canvas. It shows the conation of raw earthen material slapped, stroked and molded at a pace provided by the doubt and fear. Every move way in the struggle of one to the other, merging the past to the present, brushstrokes of colors seen but not known. For when the wailing stops, the pieces settle down in abject beauty erected for a century of a century. Speaking, advocating, protesting as the arts are meant to be.
Maya Angelou was a civil rights activist, poet, and award-winning author known for her acclaimed 1969 memoir, I Know Why the Caged Bird Sings, and her numerous poetry and essay collections. Angela was born on April 4, 1928 in St. Louis, Missouri. Angela had a difficult childhood. Her parents split up when she was very young. Around the 1960s, Angela lived in Ghana working as an editor and a freelance writer. Angela also held a position at the University of Ghana for a time before she joined a community of revolutionist returnees exploring Pan-Africanism and became close with human rights activist and black nationalist leader Malcolm X and Martin Luther King. In 1961, Angela appeared in an off-Broadway production of Jean Gennett's The Blacks with James L. Jones, Lou Gossett Jr. and Cicely Tyson, and went on to earn a Tony Award nomination for her role in the play Look Away, 1973, and an Emmy Award nomination for her work on the television miniseries Roots, 1977, among other honors. Angela's career has seen numerous accolades, including the Chicago International Film Festival's 1998 Audience Choice Award and a nod from the Acapulco Black Film Festival in 1999 for Down in the Delta. She published 7 autobiographies, 3 books of essays, several books of poetry, and is credited with a list of plays, movies, more than 50 honorary degrees, and television shows spanning over 50 years. She also won 2 NAACP Image Awards in the Outstanding Literary Work Non-Fiction category for her 2005 cookbook and 2008 Letter to My Daughter. After experiencing health issues for a number of years, Angela died on May 28, 2014 at her home in Winston-Salem, North Carolina. In May 2021, it was announced that Angela will be one of the first women to be commemorated with a new series of quarters from the U.S. Mint.
Welcome back to Politics Tonight, everyone. Thank you very much for staying with us on the program. Madaki Gwaza Michael, lawyer, public affairs analyst, is my guest tonight. And we're still discussing the removal of the Benue Chief Judge and matters arising. Mr. Michael, thank you very much for staying with us on the program. So if I got you correctly, what you've said to me tonight is that the Supreme Court was wrong with that 2009 judgment. And your colleagues who have said, with this particular case, due process was not followed. You've tried to tell me tonight that all of your colleagues are wrong. Is that it?
No, that's not what I'm saying. What I'm saying is, if you read the true letters of the Constitution, the actions that the State House of Assembly took were correct. And I'm also telling you that this notion that we have, this idea, this thing that has been put all the way out there that the NJC is as powerful as an arm of government is not anywhere founded in the Constitution. And I went ahead to say that if the NJC is that strong and that powerful, moved Justice Onogen, who by default also doubles as the chairman of the NJC itself. In 2019, when that happened, President Buhari simply removed Justice Onogen by allegations that were declarations. The NJC was not involved. And that is exactly what Section 292 provides. When I made mention of senior advocates filed a case before the Supreme Court, to have the court step in and make an impute and make a direct declaration to hold that what President Buhari did was unconstitutional. The Supreme Court looked at the entire suit and dismissed it on a technicality that they did not have standing to bring the suit. That was a missed opportunity for the Supreme Court to lay the matter completely down. So far as that was not done, it creates a situation of weakness in the pronouncement that it made in 2012. What this means is this: the Supreme Court itself has declared in many cases that it is not infallible. The Supreme Court does not go to situations where even when it feels it is reading a particular provision of the law wrongly, keeps insisting on it. No.
And I like how you're shifting grounds tonight, because basically that's what lawyers do. But Section 292 presupposes that you must determine that he's incapable of carrying out his responsibility, whether arising from infirmity of mind or body, or for misconduct or contravention of the Code of Conduct. The Constitution was not clear about what constitutes misconduct or contravention of the Code of Conduct. But as a legal practitioner, what constitutes or should sum up as misconduct? So it saves us from this kinds of abuse we've seen in recent times. I mean, because we know that politicians will always take advantage of the lacuna in the Constitution.
Okay, so that now leads us to a situation where we have had the Constitution since 1999 to today, and we've had many opportunities to amend and to make it strongly so that lacunas and gaps are breached on issues that are very important. To define the issue of gross misconduct, or what amounts to whatever description, goes back to be rested with the legislature, because that is where the Constitution makes reference to. That it is on those bases that the House will pass an address by 2/3 majority, an address that is a resolution. So to make that determination, it is vested in the House, which is populated by members elected by the public to represent them. So in a way, that determination rests with the people. So we have an opportunity here. Look, we can make any form of argument and take it here and all of that. But to be honest, there's a situation in the Constitution, clearly from the provision that you yourself read, that if it is felt by whoever in the country that the heads of courts should be firmly protected away from the prying eyes of politicians, then that very section should be amended to clearly put that the NJC is required with the governor and the House of Assembly to remove heads of court. So far as that is not there, any action, including by the Supreme Court itself, to interpret the Constitution in ways that goes beyond what the law is provided for, it amounts to even lawmaking, which is the constitutional role of the legislature.
Perhaps we should also talk about this controversy surrounding the number of legislators who voted in favor of that removal. Honorable Samuel Agada was on the program last week, where he says 13 members, including himself, they didn't vote. So the House did not have 2/3 required to carry out that exercise. The other party is saying some of the 13 members voted, but thereafter denied because their paymasters or godfathers had reached out to them to deny their involvement in the removal of the CJ. And I also remember that Honorable Agada also alleged that the other members were bribed to vote in favor of that removal. I mean, there are so many issues, and sadly there is no evidence on ground to support both sides. But how much more of this must we see before we realize the kinds of threats this violation of the Constitution and flagrant disregard for court judgment pose to democracy?
Okay, so I was not in the House on that day devoting to of proceedings that happened. And from the conduct, the House was led by the Majority Leader, Honorable Sate Tise, and the Speaker, Honorable Dajo. And when they called to divide the House and call for a vote, in fact, the call for a vote was moved by Honorable Becky Opin. She was the one that moved the House, that the House should go into a vote to end the further debate on the matter. It was from her urging that the Speaker called for the division of the House and called for a voting. All of this is on tape. It was recorded.
Have you seen the tape?
Yes, I've viewed the tapes. They were placed on various social media, perhaps we'll provide links and all of that. In the process of that voting, it was a complete 23 members voted. 23 members voted. That is why it was a bit taken aback when after the voting, 13 came out to say. So
what do you make of the suspension of these lawmakers who said they did not vote? They said they were not part of that process. I mean, you said you were not on the floor of the assembly that day. They are saying the counting was rigged. Even after the outcome, they were denied audience to voice their opinion. And to that, what had just happened?
So all the way back again, if they are, I think even on that position, the House went ahead to suspend them or take some sort of disciplinary action against them. If they have issues that relate to that, that they do not agree with the action of the House and all of that. Again, Section 6 of the Constitution provides that you do not go fighting with each other, but you simply go to court and lay your case so that everything goes smoothly and according to the laws, including the House rules. So it is not about going all over the place and heating up the polity and all of that. But
Mr. Michael,
if we're really honest with each other, let us just follow.
Let me ask you, you're a legal practitioner. What is wrong in bringing the matter to the public if, as they say, their voices were not recognized when they tried to table their grievances on the floor of the assembly, when they say due process was not followed? If what they did was against the rules of the House, then don't you think they should have been given some minutes to air their grievances? You're a legal practitioner. What is wrong with that?
Okay, so, and again, this is what I'm saying, that I was not in the House, but activities of the House can only be conducted by the rules of the House. From the video I saw of the proceedings that went for voting, perhaps I didn't see everybody that voted, but the votes that were counted were 23. There are videos to that effect. For people to come back now and say that they didn't vote, you can't. Okay, if you make press conferences, if you go and fight, and if you do all of this, what does that amount to? It is only when you go to court and the court looks at the entire evidence and makes a decision and gives orders that the House should return you back activities that have happened in your absence, that you get justice. So we cannot continue in the situation where once you disagree with a particular point of action, then you heat up the polity, you fight all over the place. We are all they are lawmakers, for God's sake. They know what the law is. If they've taken these steps that they do not agree with, fine, they've issued a statement in this direction, they should simply go to court and file a case against to restrain the House from taking this decision it has taken, and then an order to return them back to the House, including all the various finances and entitlement that those orders sought to take away from them.
All right. I mean, at the moment, NJC has spoken, and it's surprising to hear you say the council is powerless. NBA has also spoken, calls it a brazen assault on the Constitution. Benue APC categorically dissociates itself from these actions, but the State Assembly stands on its decision. How do we ensure that this does not lead to anarchy in the state?
Okay, so now, if we say we are going to fight each other, that is where anarchy comes. But if we have a disagreement that we do not agree with what position was taken by each other, we take the proper step. Let's go to court and resolve all these matters. After all, the NBA, the NJC, and all of us, what we are talking about is to protect the judiciary so that it stands independent to be able to give us proper judgment to regulate the society. So why is this matter now different for us to not go back and get judgment that resolves everything for us? You see, I think on the long run, we are more interested in the politics of the matter. And for Benue State particularly, the issue goes into the very nature of how APC is being played in the state, where the party is split directly in the middle with the governor on one side and the big people from the National Assembly and the Abuja politicians on one side. This is simply what is happening that has come all the way back into the state. What we are seeing is a symptom of what politicians have done to themselves by bringing up issues that are not necessary, that are not related to governance, and then in a way are going to include the judiciary to cause anarchy in the whole system. But again, all of these things can be resolved if we simply go back to the judiciary, table our matters very clearly to get judgments pronounced upon. That's my position.
And again, another angle to this conversation is allegation made by Honorable Justice Ekwambese over his refusal to appoint certain judges to sit on the Election Petitions Tribunal for the local government election. The local government election was in October, and the Election Tribunal has been set up to look into several allegations raised by other political parties. There are those who say the tactics of the governor is for him to scuttle the process by making sure that the tribunal does not finish this case within the stipulated time, which is 180 days. And we all know that in a situation where the election tribunal does not preside over a case in the 180-day time frame, the case is presumed dead at that level. How do you analyze the situation?
Okay, so I've heard what my lord has said on the matter, and for me, I think it was not needed for my lord to come out and make those kind of statements. There is a video that I watched over the weekend that, where he was at a public forum and made statements, allegations that he was being forced, just like you said, to appoint bad judges to handle these cases. But he didn't want to appoint these bad judges. That is why he appointed judges that are going to be difficult for the governor. I mean, these are words of the chief judge. With the greatest respect to my lord, there's dignity for the court to maintain some level of silence, and quite particularly when those issues are out there for the relevant authorities to adjudicate. Now, having said that, on the issue of the election petitions as regards the conduct of the petition, it is even part of those things that brought up the issue. The House alleged, it is alleged in that petition that some rules that have to do with paying cost and security for petitioners, they have to pay that as a mandatory requirement before their petitions can be properly filed. It is part of the law that is filed by the Benue State House of Assembly that you pay security and cost before your petition is properly filed. The Chief Judge issued a letter on his own ordering that that cost should not be paid. And this is the issue. For all the parties that were supposed to be petitioners in this very matter are lined up on the part of those people that are based in Abuja doing APC politics in the states. So that particular letter that the Chief Judge issued that says the law, the part of the law that requires mandatory cost should be done away with, is even one of the issues that came up before the House.
But Mr. Michael, let me come in there, because if you had said that, please let me come in there. If you had said to me tonight that the Chief Judge shouldn't have said what he said, but you're also here in another breath making allegations that cannot be substantiated.
No, the letter is a public document. It was issued on the instructions of the Chief Judge of Benue State. There's a letter to that effect that cost for fees should not be paid by petitioners. It is not, and that the people that are the petitioners that took advantage of that letter, of those instructions, are on the part of politicians that are based in Abuja. This is also a fact. So perhaps these are the issues that came up, and for that one particular that it relates to a law passed by the House of Assembly. You know, I'm not saying the Chief Judge cannot defend himself, but at the appropriate quarter, if a petition like the NJC, this very petition has been recommended to the NJC to remove him as a judicial officer entirely, he's going to have his day with the NJC to make his case when that petition comes up. But at a public event, there are videos of this as well, where he stood there to say that he was being forced to appoint judges that are bad. It is the Chief Judge that said that. I didn't say. So
I think the word he used was pressured, not forced. But let's deviate a bit, Mr. Michael. Analyzing the election petition procedure in Nigeria, is 180 days enough to determine all cases before them, especially now that it has become a tool in the hands of state executives?
Yes. Okay. So the intention for all of this was to make sure cases are dispensed with forthwith and without time wasting, so that if you are the proper person, you come into office, and if you are not the proper person, you find a way out of that office. But how do you now relate that in a situation where the Chief Judge himself has gone ahead by his own declaration to set up panels that are going to be difficult for another party? So the issue of 180 days is there, but you have different people.
Because these are I can authoritatively say that these are allegations that you can also substantiate. But I want us to stay on course, because I was asking you about the election petition tribunal, and holding the tribunal to ransom allegedly looks like, you know, a dent on the judicial arm of government and a denigration of the independence of the judiciary. You're a legal practitioner, so what's the implication of this on the judiciary?
In terms of what? In terms of whether the 180 days are running or not?
Absolutely. And
the matter has been declared very clear.
A further amendment of the electoral law.
Okay. Well, perhaps again that discussion can be had in terms of a further amendment to provide for exceptions here and there. But until that happens, the law is very clear, as established by the Supreme Court, that the 180 days rule is firm. And because election petitions are not like any other kind of trials, they hold 720, they can hold for 24 hours of the day and 7 days of the week. We've had situations where in regular election petitions that involve the general election in the country, where at the Court of Appeal, cases were heard all the way into the AMs. 1 a.m., 2 a.m., we're still at the Court of Appeal for petitions and all of that. So if the time is getting tight, you know, the judges, because the election petitions procedure is sui generis, is of a special nature, they can go ahead in order to abridge that time and make sure they don't go beyond that, hear cases for all the time that they have so that they don't go beyond 180 days, because that has been provided as a sacrosanct deadline that cannot be toyed with.
And you know, I'm asking all of these questions because Benue State, for instance, has had its own fair share of political instability, communal crisis and insecurity for a while now. Governor Ale is also battling internal party crisis. But when issues like this happen, where an authority can just assume power it does not have under the law, because I'm staying with those who have said this is illegal and which can automatically lead to, you know, anarchy. For instance, also, the role of the Attorney General of the state. What is the role of the Attorney General of the state in matters like this, especially because of the recurrence nature of this matter in different states? Mr. Michael, did you get that question? Mr. Michael, are you there?
The Attorney General of the state. Yes, I'm here.
Okay, please go ahead. Please go ahead.
Hello? You can hear me?
Yes, I can. Please go
Okay,
ahead.
so I'm saying the Attorney General is the directing legal mind in the state, and Benue State is
Mr. Michael, are you there? Please go ahead if you could hear me. All right, sadly we're having issues connecting with Mr. Michael Gwaza Madaki, but sadly that's where we may have to end this conversation tonight. Thank you so much for watching, everyone. That marks the end of today's episode of Politics Tonight, but you can watch the repeat broadcast of this episode at midnight. Get in touch with us on our social media handles, Facebook, Instagram, and X at TVC News NG, and at Olajumoke using the hashtag Politics Tonight. We're also on YouTube at youtube.com/TVC News Nigeria. I'm Olajumoke Olatunji. Good night, everyone.